Of the Noor Salman trial here on clickorlando.com. Thank you for being with us. I'm Julie Broughton. It took 38 minutes to seat the 12-person jury and 6 alternates. Attorneys with the U.S. government and the defense sorted through the 57-member potential pool. Today in court, Salman was engaged and had her say in the process. And for the first time, we also saw her family from California. They told us they would not have shown up to the trial if they didn't think she was innocent.
I know she's innocent, and I know 100%. So I'm gonna go all the way to support her.
Mike DeForest at the federal courthouse, and you've been following everything very closely out there today, Mike.
Hey, Julie. Well, late today we had the jury seated, 12 jurors and 6 alternates. The interesting thing about this is we cannot tell you anything about them. We don't even know how many women and how many men are on the panel until we get our first look at them when opening statements begin Wednesday. And the reason for that, throughout jury selection, they've been referring to each prospective juror by their juror number, say juror number 234. Well, when they finalized the panel today, the judge and the attorneys did not speak the number of the juror that they were choosing. Instead, they wrote them down, so none of us who were spectators in the courtroom had any idea which jurors were being selected and which ones were being dismissed. We are joined by attorney Mark O'Mara here. The judge did not say that the reason they were doing this was just an added layer of privacy for those jurors, but I got to say the end effect is we don't know anything about the men and women who are on this panel right now.
Well, that is Judge Byron's intent. He's going to give as much anonymity to this jury as he can. There's a lot of polarity with this case. People on both sides, people on many different sides, and what he's going to do is make sure that the jury, as they're going through this, do not feel that additional pressure inside the courtroom that we all feel outside the courtroom.
Because during jury selection, we may have known that juror 251 was a female who lived in Brevard County and worked for the school district or something like that. We do not know if that particular description, even though we don't know her name, is on that panel or not.
And that is intentional. That's the way Judge Byron wants to keep it as long as he can.
Well, opening statements are scheduled to begin first thing Wednesday morning, 9 o'clock. They had to take care of a couple housekeeping matters late today. The judge ruling on what some final questions of what evidence will and will not be allowed at trial and what the attorneys can say during opening statements. And one of the key questions that the defense had was they wanted to know whether prosecutors were going to suggest during opening statements that Omar Mateen specifically targeted the Pulse nightclub because it was known to the LGBT community and that he was targeting the gay community. Well, during this hearing, the prosecution acknowledged, no, we are not going to suggest that this was based on targeting the LGBT community.
You know, it's interesting, and as a defense attorney, if I was this defense attorney, it'd be particularly frustrating because we know now the government knew that months and months and months ago, probably within a month or two after the beginning of the investigation. So they had that forensic evidence that would have supported the conclusion that this was not targeting Pulse and therefore not targeting the gay community. So it's sort of frustrating both as a community member and as a defense attorney that this pretense was presented by the government for the past year and a half or two when we now know it wasn't true.
That's right. In court, the government did acknowledge that Omar Mateen, prior to shooting up the Pulse nightclub, had been at Walt Disney World and at another Orlando nightclub, Eve Orlando, we know within about 90 minutes of the Pulse attack. So obviously there could be this perception that he was kind of trying to narrow down his targets up until the minutes before he opened fire.
Either that or Pulse was truly the coincidence of when he did his search for downtown Orlando nightclubs, he came up with Eve Orlando, came up with Pulse. It's horrible to think that it could have been pure coincidence, but it seems like the forensic evidence supports exactly that.
Now, the prosecution wanted to be able to let jurors hear from 2 different 911 calls made by victims inside the club as this was going down. We know that one of the victims who was on the phone with 911 ended up dying. They came to an agreement that only one of those 2 911 calls will be admitted. The prosecution was, Noor Salman's attorneys were really trying to fight any of these, just saying that it's just piling on, kind of explain the prejudicial value of a 911 call, particularly in this case.
Well, here's the thing. We're trying to deal with whether or not Miss Salman did what she did based upon the indictment that she has. And any type of emotion, anything you bring in, the voice of somebody who died or somebody who may have died at the Pulse nightclub, you know that that's going to bring in just that raw emotion. So then the question is, under our very rules, what probative value is that evidence compared to the prejudicial value? We know the prejudicial value is outrageous. So where's the probative value? What does it add to the government's case? My understanding is they're going to say, well, it explains the way the police acted so aggressively because maybe they thought there was more than one co-conspirator. But Mike, quite honestly, what does that have to do with anything dealing with Ms. Salman?
And I want to get into that because the one 911 call that they are going to allow, the prosecution basically hinted that the reason they want this one particular call in is because the person on the phone basically says they are shooting at us. They meaning plural, suggesting that there were multiple gunmen. Now that 911 call is going to be allowed in. So is an audio recording we just learned about last night. One of the victims who was inside the restroom while this hostage standoff was going on for several hours apparently had their phone recording. And so you could hear the everything that was going on in the bathroom, and we saw the transcript of this. And what's interesting is during this, Omar Mateen makes what prosecutors describe as a fake phone call. He's on the phone pretending to talk to somebody on the outside. They say it wasn't a real call, and in this fake phone call, he's pretending that there are fellow gunmen surrounding the nightclub planning to open fire on the police who are responding, and even hinting that some of the victims lying dead in the nightclub might be pretending to be dead because they were co-conspirators with him. Again, the government says none of this was true, but the reason the government suggests that they want the jury to hear this is to explain why the FBI may have been a bit aggressive in questioning Noor Salman.
And I do think what they're going to say is, since we didn't know what was going on in the club, we don't know how involved she was. And I've got no problem with an aggressive interrogation of a witness under that set of circumstances. It is what we call exigent circumstances, something that it has to be addressed right away. My greatest concern, and we talked about this before, is even though you might agree to be a bit more aggressive because of the immediacy of the interrogation, why not tape it? Why not have an audio tape? Why not have a videotape so that not only do you get the information you might need immediately, but we can review it afterwards and see how legitimate the interrogation actually was.
Now, I don't remember off the top of my head how long the FBI's interrogation of Noor Salman was. I know it was several hours. They made a point of introducing photographs that show the wide open conference room, the restroom that they allowed her to use, basically really showing that we weren't giving her the third degree in this. But at least to me, kind of observing this, it does seem that they are really wanting to make it clear to this jury that this was not an intense interrogation. Right. Perhaps they know that that suggestion may be raised.
You know, and the concern, look, the FBI is the best law enforcement agency in this country by far, and they're professional. I like them. I like the quality of their work. I am frustrated because they seem to have a policy of not audio taping or videotaping these type of interviews, and that's very frustrating to me as a criminal defense attorney. No, there was no rubber hoses. There was no denial of food or water. I get that. My frustration is we live in a day where everybody carries with them a video recording device. Let's go ahead and use them.
Now, the defense has made it clear they are going to try to suggest that during this FBI interrogation, Noor Salman was basically coerced into making a false confession. And one of the things she told FBI that happened was she said a couple days before the Pulse nightclub attack, she actually witnessed her husband, Omar Mateen, looking at the website for Pulse nightclub. Now, in court today, the judge agreed that prosecutors can tell the jury about this so-called viewing of the Pulse nightclub website. But prosecutors admitted today in court that there is no forensic evidence actually confirming that Omar Mateen visited that website. They've looked at his browser history. They've looked at the IP. There is no proof that he actually was at that website, but yet it was Noor Salman saying, I looked at it with him.
Well, and I got to tell you, I think that feeds into the defense perspective that this is an interrogation or a, quote, confession that was sort of portended by FBI. Because if, in fact, the interrogation has information which is provably false, provably untrue, possibly presented by the interrogators, then it actually works in favor of the defense argument. In effect, if I'm making up what I'm making up because you're telling me to make it up, then it's a false confession, and none of the confession or interrogation should be believed. That may come back to haunt the government more than they realize.
It's going to be a fascinating case to watch, Mark. We really appreciate your analysis of this. Opening statements scheduled to begin in this case Wednesday morning. The attorney's taking the day off tomorrow. We will be here with live coverage throughout the day. ClickOrlando.com and on News 6. Attorney Mark O'Mara, thank you again. You'll be with us the whole time. Back to you, Julie.
All right. Thank you so much, Mike DeForest and Mark O'Mara. Our coverage of this trial continues online tonight. We have a special page detailing everything on clickorlando.com/Noor Salman tab. And don't forget, we have a team of reporters in the courtroom for the latest. Head to twitter.com/News6Pulse Trial. Join us tomorrow morning for another discussion. Our coverage begins at 8:30 right here on clickorlando.com. Thank you for joining us. I'm Julie Broughton. Have a great night.